Hello, this is Captain Chaudhari. In my recent videos, I've been talking about the difference between Hague Visby Rules and Hamburg Rules. We have been talking about the differences in respect of various issues, but today I'm going to talk about the difference in the two rules. We'll be comparing the two rules as far as notice of damage is concerned, the time of suit is concerned, extension of time of suit is concerned, arbitration and jurisdiction. So let's see what paragraph 6 of Article 3 Hague Visby Rules says. It says that the notice of damage has to be given to the carrier or his agent at the port of discharge before delivery. Right? And this is to be done for apparent damage. Whereas if the damage is latent, you can't see the damage at the time of discharge, 3 days are permitted, within 3 days. Otherwise, it will be considered as prima facie evidence of delivery as stated in the bills of lading. Under Hamburg Rules, Article 19, it says notice of loss or damage must be given in writing by the consignee to the carrier not later than 1 working day after the goods were delivered to the consignee, or where the loss or damage is latent within 15 consecutive days after delivery to the consignee. A failure to give such notice is prima facie evidence of delivery in accordance with the document of transport in good condition. So it seems it would be assumed that the delivery has been done to appropriate consignee in good condition. So what we see here, when we compare the two rules, the extension of 1 day and the extension of 12 days respectively has been done for apparent damage and the latent damage respectively. Next we'll talk about time of suit. Let's first see what Hague Visby Rule says. Once again, under paragraph 6 of Article 3, it says that subject to the provisions of 6 bis, the carrier and the ship shall in any event be discharged from all liabilities whatsoever in respect of the goods unless the suit is brought within 1 year of their delivery or of the date when they should have been delivered. On the other side, Article 20 of Hamburg Rules is limitation of actions. It says that any action relating to carriage of goods under this convention is time barred if judicial or arbitral proceedings have not been instituted within a period of 2 years. So what we see here is, from the wording, that 1 year that is provided in Hague Visby Rules, it is stated from the standpoint of carrier, from the point of view of carrier, that he will be relieved of all the liabilities whatsoever. It does not talk about, whether the other party is satisfied, whether the cargo interests have got something which is unsatisfied and not clear. It does not talk about it. Whereas if we look at the Hamburg Rules, it is basically the time that is allotted, that is 2 years. It is from the standpoint of the other parties, because it says that, and the area is much wider. It says that any claims, any kind of actions, they are welcome within 2 years, right? It means that the field of activity, field of action is much wider when we look at the Hamburg Rules, and it is not solely from the standpoint of carrier. It does not say that the carrier is relieved of liability. It says that any action can be brought within 2 years. That's the difference. Then the Hamburg Rules say in paragraph 2, the limitation period commences on the day on which the carrier has delivered the goods or part thereof. In case where no goods have been delivered on the last day on which the goods should have been delivered. That means there is a specific, crystal clear indication of what is the moment when this limitation period should start. Right? It also says that even if the cargo is not fully unloaded, even if the goods are not fully delivered, even if it is partly delivered, the time starts. So now let us talk about the extension of this limitation period, this time period of 1 year and 2 years respectively, what it says in Hague Visby Rule and then Hamburg Rule. In Hague Visby Rules, it says that the two parties must mutually agree. If they mutually agree to extend this period, it can be extended beyond 1 year. Whereas in Hamburg Rules, it is not the mutual agreement of the two parties. It is like it stated that the declaration from the defendant should be there. Looks like the 2-year period that is provided in Hamburg Rules originally, is sufficient from the claimant point of view. Looks like this period is enough so that the interests can be protected, right? Whereas if the defendant declares that this period can be extended, right? There is a declaration to this effect, then the period, and that declaration has to be done within the 2 years period so that it can be extended. And then later on it can be further extended. In that extended period, once again, if there is a declaration or declarations, the period can be further extended. Article 6 bis of Hague Visby Rules is about indemnity. It says that the action in respect of indemnity or for indemnity can be taken against a third person even after the period that we were talking about, that is the limitation period, is over, provided the action is taken or instituted within a period that is allowed by the law of the courts seized of the case. It says, however, that this period will not be less than 3 months counted from the time that the person who's instituting this action for indemnity has settled the claims or has been served with the process in action, right? Something very similar has been stated also in Hamburg Rules. There is no much difference except that the initial limitation period in Hague Visby Rule is 1 year and Hamburg Rules is 2 years. Now Article 21 of Hamburg Rules is jurisdiction. As we know that in Hague Visby Rules there is nothing that has been stated about the jurisdiction. So let's see what Article 21 says. So paragraph 1 says that the plaintiff at the option may institute an action in a competent court with due jurisdiction situated at A, the principal place of business or, in the absence thereof, the habitual residence of the defendant, or B, the place where the contract was made, if defendant has there a place of business, etc. Or C, the port of loading or the port of discharge, or D, any additional place designated in the contract of carriage by C. So by the paragraph D, it looks like there is a possibility that in the contract of carriage there will be agreement in respect of a place of jurisdiction. However, from the wording it also looks like any of these options can be chosen by the claimant, not the defendant. Then in paragraph 2a it says that notwithstanding the preceding provisions of this article, an action may be instituted in courts of any port or place in a contracting state at which the carrying vessel or any other vessel of the same ownership may have been arrested in accordance with applicable rules of the law of the state and of international law. However, in such a case, at the petition of the defendant, the claimant must remove the action at his choice to one of the jurisdictions referred to in paragraph 1. Now, under Hague Visby Rules, there is nothing that is stated in respect of jurisdiction or arbitration. But as we know that under Hague Visby Rules, there is a freedom of contract. One can contract, the parties can contract so long as the liabilities and responsibilities of carrier are not reduced. Let us see what Article 22 of Hamburg Rules says about arbitration. It says, subject to the provisions of this article, parties may provide by agreement evidenced in writing that any dispute that may arise referring to the carriage of goods under this convention shall be referred to arbitration. In the second subpara, it says, where a charter party contains a provision that disputes arising thereunder shall be referred to arbitration, and a bill of lading issued pursuant to the charter party does not contain a special annotation providing that such provision shall be binding upon the holder of the bill of lading, the carrier may not invoke such provision as against a holder having acquired the bills of lading in good faith. So you can't thrust arbitration upon a holder of bills of lading where he has acquired bills of lading in good faith and nothing about arbitration, nothing mandatory about the arbitration has been stated in bills of lading. Arbitration and jurisdiction, although they are to be conducted at similar places, the places where arbitration or jurisdiction lies are same, as we see in Article 21 and 22 of Hamburg Rules. But in respect of arbitration, there should be an additional agreement that should be done, right? And if it is not stated in the bills of lading and the holder of bills of lading finds the bills of lading without such mandatory provision in respect of arbitration, the arbitration cannot be thrusted upon on the holder of bills of lading.